story that my law professor told me when I was in law school. It's about this farmer who's out in Saskatchewan and he owned this farm. And then suddenly something happened, some sort of an accident. The tractor tipped over and he actually got pinned under the tractor. He was stuck there for a long time, a couple of hours. And I think he must have realized that this must be it. Somehow I think got a piece of cloth out of his pocket or something. He was thinking about his family because he didn't really have a will. So he takes out this piece of cloth and he scribbles on it that he wants to leave his farm to his son. Unfortunately, he passed away that day.
I thought a will is a legal document, a lawyer has to sign it. So how come like anybody can write a will and by their hands and that's enforceable? Like, is that okay?
If you are married, you have no kids, then most of the property would go to your spouse. If you're common law, then you don't have any entitlement to inheritance, as these intestacy rules.
Okay.
All right.
How's it going, Hasan?
Pretty good, pretty good.
So, tell me the craziest stories you've had in your experience or you've heard basically when it comes to like death and estate and wills.
Yeah, so there's one story that actually stands out that I recall prominently, and it's a story that my law professor told me when I was in law school.
Yeah.
It's about this farmer who's out in Saskatchewan and he owned this farm. And one day he was actually working on his farm. It was early morning. He was all alone. I think he was on a tractor, just working around his farm. And then suddenly something happened that some sort of an accident. I think he fell down or the tractor tipped over or something. And he actually got pinned under the tractor. And he was stuck there for a long time, a couple of hours. And throughout that process, while he was trying to get himself out, the only thing he could think about was about his family and what would happen to his family if he couldn't get out of there. So I'm sure he must have tried everything he could, but at the end, he kind of was he was pretty weakened by the whole process, and I think he must have realized that this must be it. This is the time, and he somehow I think got a piece of cloth out of his pocket or something, and he was thinking about his family because he didn't really have a will. Mm-hmm. So he was like, what would happen to the farm? What would happen to everything? So he takes out this piece of cloth and he scribbles on it and basically says this is what his dying wish is, that he wants to leave his farm to his son, so on and so forth. And unfortunately, he passed away that day. And but the only thing that he had was this one piece of cloth with his wishes on it. And most people would think that, you need a will. So that piece of cloth actually was his final will.
So, well, that's super interesting. So, like, I thought that a will is a legal document. You can't, like, just go to anybody. You need to witness it. Commissioner of oaths, someone like you, a lawyer, has to sign it. So how come, like, anybody can write a will and by their hands and that's enforceable? Like, is that okay?
Yeah, no, that's a good question. So basically there's an exception. You see all these rules and things about witnesses and everything, there's a background for it, some reasoning for it, but there's an exception to all those rules, and that exception is that if you write the will in your own handwriting and it is under certain serious circumstances which you're expecting,
like life or death
situations, and that's your dying wish, then that document is considered your will, and you don't have, even if you don't have witnesses or it commissioned, it would be sufficient for that purpose.
And that's like an understanding a law within Ontario or like across Canada, like
so
how would this be placed?
I believe this is a pretty common law principle. Like I said, this was a story from Saskatchewan, so it's pretty common. And I was in Nova Scotia at that time, so it's a common principle. I think it's common law in any province in Canada. This would be sufficient. But again, these exceptions are for dire circumstances.
So let's say if that farmer had passed away without a will,
Yes.
what would happen?
So that's a good question.
Like, I know he's thinking about, okay, like if I don't write a will, maybe people will not get their fair share that they should be entitled to. But like a lot of times a lot of Canadians don't have wills. That's what I see in my practice.
Mhm.
And oftentimes we end up getting our wills done. We worked on a lot of projects together, so you've seen those.
Yes.
But what if you die without a will? What happens legally?
So generally, if you die without a will, there are multiple risks that we really don't know where the property would go. Like if you want the property to go to a particular place, it might not end up there. There are certain rules that the law says that the property will go to certain people if you don't have a will. So it may go to places where you don't want them to go. The other problem you may
And
have.
the will deals with like all the assets the person owns, basically.
Yeah. So basically, a will is generally a will is to determine where your property will go after you pass away. And the purpose of the will is that there's the person's wishes properly documented, which shows where it would go. And more importantly, the will is important because it identifies who your executor would be. And that's the individual who manages your property and makes sure it goes to where you want it to go. So you are asking about what happens, how does the property get distributed if you don't have a will?
Yeah, if I didn't write anything, if I died without a will, there's no obviously written wishes, how I want my property to be distributed, then what would happen in that
situation?
Would the government take over my assets? Would family members lose control of my assets because they don't have it? What happens?
Yeah, so and that all of that could happen. So in order to, because it could be pretty chaotic if you don't have a will. So the government, what they've done is they've passed some legislation just to provide some baseline rules on distribution of property. Because one of the biggest issues that people have is contentious claims on assets of the estate that people may make claims and fight over it. So especially if you don't have a will. So what the government has done is they've passed legislation and they've kind of given us a hierarchy on how the property will be distributed. So it's in the intestacy rules in the legislation. And the way it goes is that if you are married and you have no kids, then most of the property would go to your spouse. Okay.
And is that, sorry to interrupt, but is that legally married spouse? Is that common law partner?
Yeah.
There's so many meanings of spouses these days, you know?
No, that's absolutely right. Essentially, the rules apply to married couples. If you're common law, then you don't have any entitlement to inheritance under these intestacy rules.
So you have a spouse, no children. Most of it goes to the surviving spouse.
Now, if you have a spouse and children, then the rule says that the first $350,000
of value
would go to your spouse. If your estate is bigger than $350,000, then the rule says that 1/3 of it would go to your spouse, and the other 2/3 would go to your children, depending on the number of children you have.
Got it. So, okay.
So
and is that Ontario or is it Canada-wide rule?
So this is Ontario, but across Canada, there are similar rules. I think the other provinces may not have this preferential share of $350,000, but the general rule is that it's the immediate family who would benefit from the assets of the deceased. So there's a whole hierarchy, right? So I'm kind of going through it.
It's like a waterfall.
Yeah.
So, we spoke about having no will at all. That's a failure, right? And that's what we got into. But what would be like the other two circumstances where the wills would technically fail? So like I'm thinking of, I see that people have wills and sometimes they just are like 10 years old. Like I had a client, I looked at their wills not too long ago, and the person is in his, 35, 36 years old. the last time he had a will was when he was 24, 25. I'm surprised he had a will, by the way, at that young age, because most people don't. I think somehow he had the, insight that he should do it, and he did it. And then I looked at his will. In his 20s, obviously, he was not married, no kids, little to no assets to his names, and then he became very successful afterwards. So in his like mid 30s now.
Yeah.
Completely different family structure, completely different wealth structure, but like the will was not reflecting his current lifestyle and the current way of how he would have done things.
Yeah, I mean, I think that's one of the most important things you've touched on, is that the will is actually a stagnant document. It doesn't evolve. The document itself, or your wishes in the document, doesn't evolve, but your circumstances may. So one of the main issues that I've seen in my practice is, their circumstances have changed. So one of the biggest circumstance change would be your beneficiaries. So in your will, you may say you want to leave everything to your parents when you're not married, but afterwards, when you're married and have kids, you may want to change that distribution. So your beneficiaries may change over time. Similarly, your executors might change. So,
yeah, that's a good part. What is an executor, just so we can
yeah,
get everybody on the same baseline as our understanding?
so an executor is basically that individual who the deceased has nominated to manage his property after he's gone. So the executor is a very important role. Their responsibilities start immediately upon death. So in certain circumstances, they're responsible to collect the body and arrange funeral for the deceased. After that, the executor is responsible for collecting all the assets of the deceased. So if they have bank accounts, he needs to get the bank accounts transferred to the estate. If he has real estate, if he has investments, if he has bonds, the executor's responsibility is to go out and speak to
Every
institutions
individual
and get all those assets into the estate. And then the third most important role of the executor is to distribute this asset. So he has to first pay off all the debts that the deceased had from those assets. And only after the debts have been paid off, the remaining amount he has to distribute to the beneficiaries according to the wishes of the beneficiaries. And more often than not, you may be surprised that sometimes the beneficiaries disagree with how much share they're getting. So it's the executor who has to kind of iron things out between beneficiaries and explain the situation and try
sometimes one of the beneficiaries is the executor. That really muddies the water as well.
That does, and it'd be funny.
A lot of families have that.
You would know, yeah, because the executor is someone who you really need to trust, and the one person you would trust is your family. So you'd have to nominate someone from your family to kind of act as the executor, but they're also the mediator, they're also the beneficiary. So there's a lot of hats that the executor has to wear. And as a result, it's a pretty important role in an estate, basically.
It's a very underappreciated role when I see it, because oftentimes, estates, simpler of the estates, not even talking about complicated ones, takes a year plus to settle everything. They also take on the role of, like, you said debts, they have to pay taxes. That's a debt.
Yeah.
This is a deemed disposition of all your assets of the individuals when they die, and all the taxes have to be calculated. All the assets have to be valued at fair market value. You have to get third-party valuations done, file the tax returns, pay the taxes, and then make the distributions. Because if they make distributions before any of that, and they may be personally liable for that distribution if there was tax claim after the fact.
That's right. There's some personal liability that the executor has to bear. But you're right. I mean, questions of liquidity, right? Like you mentioned, there may be a tax bill that they have to pay.
Huge tax bill. I think we see, like, business. If there's a business owner involved, I think we see taxes up to ridiculous numbers. Tax rates, effective tax rates go to like 50, 60, 70%.
Really? That's incredible.
Because it's double and triple tax that happens.
Oh my.
And then you have to do something called postmortem tax planning, but we've covered in other videos. So bringing back to you, in a way that the executor's huge role,
Exactly.
and often underappreciated, often a beneficiary also,
That's right.
and they feel the heat
They
for
feel the
multiple
heat.
years.
And coming back to our discussion that, you know, your circumstances might change. So you may have this individual who you trusted to be your executor, but and you mentioned him in your will, but God forbid he dies before you. So
Yep.
now you have a will with practically no executor. So your will may tell us where you want the property to go, but there's nothing that tells us who's going to be responsible.
That's an interesting thing. So like if I have a will that happened to be outdated, and my executor is no longer around, they may have left Canada or they died.
Yeah.
Then who takes care of your...
So basically,
will?
in that situation, you need to, your will would still be valid. It doesn't invalidate your will. It's just that someone from your family may have to step up and make a special application to court to say that they should be nominated as the executor or appointed as the executor to implement the wishes as set out in the will.
So you can self-appoint.
So it's basically...
I guess self-appoint with the consent of the court.
Yes, you have to self-appoint with some sort of evidence that the beneficiaries are, there's no contested executorship. Because you may have a circumstance, I've had a circumstance where a family had 2 children and, they each wanted to be the executor. So in that case, it's much more litigious. But if you have everyone consent to that individual to act as the executor, then it's much more, then the court certifies it, and then that.
But they're following the wishes written, predetermined wishes that are written into the will.
Yes.
Does executor have any discretion as to who gets what? Can they make even-handed? Do they have to be, or do they follow to the T exactly what the will says?
So I mean,
because like, why would the children in your example, both of them would want to be executor? Because it's just literally an administrative procedural process, if anything, with a lot of headaches.
No, I mean, I agree that the wishes are there, but the executor still has a bit of discretion in the sense that which property to liquidate, when to liquidate it, and which property, because sometimes it's in the wills, it doesn't specify which property goes to which beneficiary.
They just say the value of the estate has to go, but it doesn't say specific property has to go to somebody.
Exactly. Because most wills just say give this much value to the beneficiary. And now which assets are liquidated to give that value would fall upon the executor to make that decision.
And do you have to give the property of the estate to a family member, or can you give it to another person who's not related to you? Does it matter? So let's say if I have an estate, an executor is there, and the beneficiaries are named, right?
Yeah.
Do the beneficiaries have to be family members, or can it be non-family member, third party, like a friend?
So
that you can distribute to?
That's a really interesting question, because if you have a will, you can actually make a non-family member a beneficiary. You have the full ability to do that. If you didn't have a will, then you go through the intestacy rules, and in the intestacy rules, it just direct family members, which are primarily your wife, kids, parents, and siblings, who get any entitlement. And your nieces and nephews are distant family members, but it has to be blood relations who may be able to get something if you don't have a will.
Got it.
But if you have a will, you can actually donate it, give it to a friend, give it to anyone.
It's really up to the person who's written the will to do whatever they want.
Exactly. It's their wishes, so they can decide what they would like to do with their property.
Got it. So obviously from a tax perspective, I just want to add a thing that, whenever there's more often than not, in my experience, I see wills structured in one of 2 ways. Option 1, which is most tax efficient, is that you leave as much or all of it to the surviving spouse, all your assets, if you're first to die, because there's a tax deferred transfer that happens. Because as you say, if somebody passes, they have now deemed to have sold all their assets, taxes are paid or triggered. And that's a huge liquidity problem, because you've sold the assets for tax purposes. You actually have never received cash for it.
That's right.
And then if you have illiquid assets like real estate, investments that can't be sold, private company shares, you really have a huge tax bill but no cash.
Yeah.
and CRA's rates for financing something is like a shark loan.
Yeah,
You know?
unfortunate, but
So oftentimes the executor has to then sell the assets to come up with the money. But then if you have a surviving spouse, let's say husband passes away, leaving the wife behind and the kids behind, we often recommend from a tax perspective that you don't have to pay any taxes if you left everything to the surviving spouse.
that's right.
And so long as whatever they receive in assets, there's no taxes to be paid in most cases. But if anything goes to anybody else other than spouse, like children or friend or parents, even siblings, then you're going to pay taxes on those specific items that are not going to the spouse.
Right.
But interesting thing, like you said, is like spouse is very specific. It's legally married couple, not common law partner.
Yeah, I think the policy behind it is basically, and maybe you can correct me, why they give you a tax-free rollover to spouses. From what I was told was, a family unit is sacred in society, so they don't want situations where a widower or a widow is financially dependent or destitute. So they want to encourage the deceased to kind of transfer all their wealth to their widow. So that they're well taken care of, widow or widower for that matter. Yeah. And if they're encouraged to do that, they get some sort of a tax break. Is that?
I really don't know what the policy reason was. I just thought that they might have done that because taxes shouldn't be triggered until it's moving generationally from one generation to another. So I thought it was a fairness issue that it's just going to husband to the wife or wife to the husband, so it should really not cause any taxation.
Yeah.
I'm in favor of no taxation at any point.
No, absolutely. I think that would be the best case scenario. Yeah. But I was just curious on why they made the cut on the generational level rather than second generation for that, or non-generation like friends. This distribution to friends may be taxed at a higher rate, but that's policy which we could.
But coming back to the couples, like, we have seen circumstances or like clients where you end up having a spouse where you leave the assets to. Yeah. But it is not unheard of where the spouses are separated but not legally divorced. Yes. I know it's a difficult question to answer. Yeah. But would you have any insight on something like this? Where
I have a pretty interesting story actually. I might want to share with you. So there was this case that I worked on where there was this individual. He was a fairly wealthy individual who was married, and he'd been married for about 20 years or so, and for some reason he separated from his spouse, but they never legally divorced. So they were separated for more than 3 years. And in the meanwhile, he got into another relationship with another lady while he was still married, but they were legally married, but he was in a common law relationship with this other lady. And he had a will. I think he had prepared the will when he was married to his wife, but he hadn't changed it. He had made that will, I guess, 10 years into his marriage or something. So anyways, the story goes that he, unfortunately, there was a fire in his house, and he had the will in the house. So the house burned down, and the will got burnt, and he died in the fire as well. So unfortunately, he had his common law partner as a survivor, and he also had his estranged wife who was a survivor as well. And unfortunately, his intentions on what he wanted to do with the will were written out in the will, but it was lost basically in the fire. So there was this contention between his common law partner, who made a claim on the assets, as well as his spouse, who said that as a spouse, she is legally entitled to the assets, whereas the common law partner said that no, he was in a romantic relationship with her, so she was entitled to some.
So who won?
So it was, unfortunately, the rules have changed on this. It was a bit murky. I think the spouse had better rights in this situation, but recently in Ontario, they've changed the rules, and they've said that if you are separated and apart, live separated and apart for more than 1 year, then you're deemed to have disqualified. You're not entitled to any rights as an estranged spouse.
So then, but then it raises a couple more interesting points. Is that we just spoke about how if you have no will and the will is lost in this case. So I have a couple points. One is that do you need that original will, or can you have a scanned copy or a copy of will somewhere else? Because in this case, maybe he died and the fire consumed the will and the whole house or whatever, but then you might have copies. Lawyer might have a copy who prepared it, and others might also.
Yeah. So, I mean, generally, we need the original will for it to be valid because the judge and the court system wants to see an original will just to make sure that there's no tampering or any issues with it. But in this circumstance, I have heard of certain circumstances where they've lost the will, but they have a copy of it. Now, the issue with the copy is that the court system would still look at it suspiciously that maybe it's been tampered with. So generally, they don't accept copies, just simple copies of it. But copies with certain evidences, maybe affidavits from people like from the solicitor who prepared it, would go towards satisfying the court's concern that there's been no changes to it. One common practice that I have, and I think I've seen a few other lawyers do this, is that they provide notarized digital copies. So if you have a will and it's notarized as of the time of execution and it's a copy, then those copies could, under certain circumstances, now I'm not saying that it would be acceptable, but it would go towards alleviating any concerns about the tampering concerns.
What is notarization? Is it like just you, lawyer, who prepared the will certifying that you prepared it, or how does it work?
So a notarization is basically saying that this document is a true copy of the original. And it's certified by a lawyer or someone who's
But then how is it protected? Sorry to give you a little bit more specificity
details,
on this.
yeah.
So like digital notarization, is it like password protected, or is it like a page that can't be tampered with, like PDF that just you cannot, screw with? What is it?
So basically, it's not password protected. It's just that as of that date, this was what was a copy. Right, and you could actually, that's one of the reasons the court's still suspicious about it. That could change afterwards. Right. Like there could have been a second will after this, or so and so forth. So what I think that document primarily assists in is to confirm the intent, that this was the intent. So if someone's making a claim, you could actually show, well, this wasn't what the intention was as per this copy of the document.
Got it. So the other question I had, and from that example you just gave me about the fire and the whole thing, notarization or having the original being lost. But the fact that common law partner in this case lost the case basically, right?
Yeah.
But is now kind of the similar thing where like, you mentioned like the rules have changed, etc. And if you're separated from your spouse for more than a year and then living apart, then basically it disqualifies you.
Yes.
But let's say in today's world, today's time, does common law have more rights? Do they get recognized from the will perspective?
So no.
If you died without a will?
No, I think I would admit this is a bit more family law than corporate or estate law in that sense. But my general sense is that there's still a distinction between married couple rights and common law rights. One of the essential rights as a married couple is inheritance rights. Although they've kind of, obviously for practical reasons, bifurcated it if you're separated and apart. So practically you're not married. They've limited those rights, but they still want to kind of give additional rights to individuals who are married as compared to common law. So if you want to provide something to your common law partner, it is essential that you do a will and you leave property to your common law partner, because if you don't,
name them, etc.
name them, because if you don't have a will, then they don't have
By
any
default,
right.
they don't have any
They have
rights.
no rights.
Now, while we're on the subject of spouses in common law, I want to throw maybe a curveball at you.
Sure.
These questions percolate because you're saying such important things. But my mind goes to it. A lot of people get married.
Yeah.
They have religious ceremonies. Or they might be married outside of Canada and they migrate to Canada.
Mm-hmm.
But they may not have a registered court document, registered document from the jurisdiction in which they were married.
But they're
How do you
living.
establish that someone's married then? Is the religious ceremony enough?
So the general rule says that if you have a foreign marriage and that marriage is recognized in the foreign jurisdiction, then Canadian or Ontario would accept it as a reciprocal rule. So they don't have to re-register in Ontario because it was already registered in the foreign. Or
But what if you have no registration?
Recognize. So
What if you
I say registered.
Yeah.
Maybe you're talking about.
Also, I'm talking about like if you didn't register, you just had a ceremony,
Yeah.
but you didn't register. Some people don't.
Yeah, no, they don't. So it's a question of whether that non-registered ceremony is recognized in the foreign jurisdiction, because you may have a foreign jurisdiction where they may not have formal registrations. They may just have like a ceremony or some sort of a document, non-registered document, which says, yeah, this marriage was performed by a person. If it's recognized in that foreign jurisdiction, then Canada, from my experience, also accepts it. But if it's not recognized in that foreign jurisdiction, so you have a non-registered ceremony which is not recognized in that foreign jurisdiction, it won't be recognized.
What about if you had the marriage in Canada,
Yeah.
religious ceremony, but not registered?
I don't think that would be considered married. I would consider that to still fall within common law. But again, this is something I'm not so sure about.
So I think the better advice to anybody would be like register the marriage also.
Yeah.
Right?
If you
remove all the questions.
If you wanna
Remove all the questions.
If you
basically,
wanna
right?
have the rights of a married couple, then yeah, I think it would be advisable to register the marriage. If you don't register it, then you still have rights as a common law partner. But like I said, those rights are more restricted than a married couple right.
You covered a lot of stuff, that what goes on the will and like all the questions related to it.
Yeah.
What I'm really interested to know is that I understand there's an executor, there's beneficiaries. What happens if you don't have a will? I'm really interested to know, because I hear this all the time, is about government taking your assets.
Right.
When does that happen? Like, what needs to happen to that extent that the government really just goes and takes your assets and you're screwed?
There
your family's
are
is
so
waiting.
many ways the government takes your assets, to be honest. I'll just give you like 3 very common ways where the government takes your assets. One is taxes on debt. That's the first one. I'm sure you've talked about that a bit, honey. So basically, you're hit with a large tax bill when you die, so you gotta pay that. So a big chunk of your assets go there. The second way that the government can take, and this is sometimes when people don't think about it, is abandoned assets. So let's just say that you have a will. You've mentioned where you want to do it. You've done all this sort of tax planning, fantastic stuff, right? But you have an executor who doesn't know what assets you have.
That is so true.
Right?
I don't think even this, if it's like a couple, maybe the couple doesn't even know that what other spouse has or doesn't.
Yeah, like there may be a bank account which they can't track. There may be some safety deposit box with gold ingots on it. So if your executor cannot find your assets, then that asset would be deemed to be abandoned. And if it's abandoned, it goes to the government. So the second.
So how would the government find out this deposit box? Like the bank will turn it over to them, or
yeah, so the bank.
Do they not ever reach out to the family and say, hey, so and so person, you haven't accessed it for so long?
Possibility, but if the bank cannot retrieve or figure out who to contact, because maybe there's an executor, maybe the family members don't have a stale address, whatnot. If they cannot trace a beneficiary, and the executor cannot find these assets, and mind you, it happens a lot, then it's considered an abandoned asset and it goes to the crown. So one way the government gets your assets is through
I wonder if
abandonment.
there's statistics on this. How much
It'd be
government
fascinating.
is able to...
Wasn't there a statistics some time ago about CRA refund checks of some
Yeah.
millions of dollars were sitting somewhere in
Yeah,
refund checks and they never got those? So
yeah, that happens. I had a client reach out to me just two months ago. I never had this question before, and they're like, "Sonny, I have this copies of checks that he's never cashed from 8 years ago," and he had like this full stack.
wow.
And I'm like,
Can you still deposit those?
no, I was so puzzled. I'm like, why do you have all these checks? Why didn't you deposit them?
Yeah, yeah.
I think they were like at least $10,000-$15,000.
Wow.
We're still going through it with CRA because we have to like.
Oh, you're
Well, it's a meaningful amount, $10,000-$15,000.
Yeah,
so we're
yeah.
we're going to CRA and like figure out is this money still available for them to pick up and cash, because I don't think you can walk into a bank with a 10-year-old check and try to cash it in the government.
That would be that's
So it happens when you're living.
fascinating. Yeah.
If you're dead
It's
and nobody knows some secret asset you got and people just don't know about it, I'm sure government is raking that in to some extent.
They would most probably, yeah. So that's another way that the government can actually get your assets.
What other ways can they take it? So you forgot about, so either you didn't pay your tax bill, the government takes over. Second, you
the
just didn't know about, you
executors
forgot
can't
about,
find your assets. So
the
that's
government
another
takes
one.
it.
And then the third one is you don't have a will and there's no beneficiaries. So this is pretty obvious. So you have no beneficiaries. So basically you don't have a spouse, you don't have any kids, you don't have a parents,
What
you
about
don't have siblings.
Oh, nobody. Okay.
So there's no one in your immediate family who preemptively goes and collects that asset. So if no one's making a claim there's no beneficiary, then basically it goes back to the crown.
But can they like also make it harder? So let's say you do have, maybe you don't have a will or you do have a will. Let's just say what I'm interested in is like when, not that the government takes your assets, but they take control of your assets. So that the family is deprived of controlling it, and now they're dependent on government delays and being able to use it.
So the government may only take possession of your assets through garnishment, in my sense, for unpaid taxes. That's when they may...
What about disputes? Let's say beneficiaries don't agree who it should go.
Yeah, so in that case, it would be most probably the executor may throw up their arms and just say, I can't deal with this, and they just submit it to court. So the court may hold on to it in trust. So that is a liquidity problem for beneficiaries, that if they're relying on those assets and it's sitting in the court with no access, then that could be a problem. But it's mostly to do with safeguarding the assets while the dispute is going on, so it doesn't get spent inappropriately. But I think the bigger problem is abandonment, that there's no beneficiaries, there's no executors don't know about it, or are you...
I had a very crazy case that I worked in. Father passes away.
Yeah.
And the adult kids are convinced that the mom killed him.
Oh boy. Oh boy.
And they don't want any asset to go to the mom.
No,
And
that's
now
a
they
pretty fascinating story.
And the kids are like in court making all kinds of like, you know, they're emotionally disturbed that this could have happened, and because they're so convinced for one way or another. And now there's a court appointed executor, and there's lawyers and accountants on mom's side, lawyers and accountants on the other side. And any bit of money that needs to be flowed through goes through a big meeting around the table where things are like quiet, dicey, and bad faith all around.
Yeah. No, there was this, and I forget the name of it, but there was this really big case out in St. John, New Brunswick, where there was this businessman, very successful, one of the big, wealthiest people in town. He was found dead in his office, clobbered to death. And they couldn't find a killer, but the person they arrested, the suspect, was his adult son.
Oh, wow.
And it's the exact same story that you have. He was the executor of the will, in the will, and he was one of the predominant beneficiaries in the will. And there was this whole court case that determined that can you have a killer receive all the assets under the will.
Yeah.
And the general rule, the general principle in law is, what do you think? Before I give the answer, what do you think? Is it fair that the murderer benefits from his own crime?
I think there's a ethical, moral issues maybe that, you kind of did a deed and your victim is going to be now benefiting you after you caused them harm.
Yes.
I would say from doesn't sound morally right or ethically right that should happen. I'm guessing that it didn't matter at the end of the day. The law allowed you to do it.
No. I would say that the general principle is no. The murderer will be deemed to have relinquished his rights to the inheritance if he kills the...
So that's written into the law?
That's a common law principle.
Oh,
so he is deemed not to benefit, so any other beneficiary will receive his share. And that is for a policy reason. You really don't want beneficiaries to go around willy-nilly killing their relatives in order to gain their inheritance. Although it could happen, but they don't want that as a policy.
I watch a bunch of shows over time, and I come across these investigative shows on TV, and like so and so killed his husband or wife because they had huge life insurance.
Yeah, exactly.
They got insurance just before being dead, and then afterwards they died, or it was either committed suicide or actually the other spouse killed him.
Yeah, no. I mean,
is that a concept here? I guess same concept would apply.
It's the same concept that if you're found, so the kicker here in that story from St. John is it all depended on his conviction. So the son,
but that takes forever.
It took like a couple of years for that to play out.
It would take 10 years.
But the son obviously was claiming his innocence. He said, I had nothing to do with it. And at the end of the day, I believe he was found not guilty.
Oh, okay.
And for whatever reason, there was some evidentiary matters there. He was found not guilty. And as a result, because he was not found guilty, he was not deemed to be the murderer. And as a result, he was entitled to the benefit. But if he was found guilty, then he would have not been able to.
But it takes forever to run a court case. So is that you're saying is that the instance when the government takes control because they don't know whether you should be entitled to it or not until the case is resolved?
Yes, no.
But if the executor is okay, I mean, in this case, the murderer was the executor.
Yes.
So if you weren't the executor but you were beneficiary, I guess you will still be off of the inheritance.
That's right.
But if there was an executor that was not the murderer but the beneficiary was, the executor will basically hold on to it, or they can distribute because they're innocent until proven guilty.
Yeah. No, they cannot distribute it until the end of the case. The court will finalizes it. But yeah, he may. It's a dicey position for the executor. I think he may not be entitled because, as we mentioned, that there's personal liability. If he distributes it to the wrong person, then the executor could be on the hook for it.
Super interesting. Where I want to go through is like the whole concept of probate for a second.
Yeah.
It's a huge deal. We have talked about it on this channel on a couple of videos where Ontario and concept can be applied in principle to other provinces across Canada.
Yeah.
Where not only you pay taxes on death, that's income tax, but then you also have to pay probate.
Mm-hmm.
Can you walk me through, from a legal perspective, the whole process around that? Why do you need it? What's in it for the government for you to be doing it? Why do they charge you this crazy amount of money?
Yeah,
and,
I mean,
what's the process really on the ground? Like when do you find out you need to be involved to write the probate or help with the probate application?
Yeah, I mean, it's a great question on finding when you need to probate, because you may have heard
what is a probate, I guess?
You may have heard stories, right? Like people say, oh, I got everything, I didn't need to probate my will, where in other circumstances people say, oh, I had to go through the court process. So it's an important question. So generally a probate is a process that you must follow when someone is challenging the validity of the will. So you may have a will, you may have an executor on it. The executor may take the original will to the bank, let's say, to get access to the deceased bank account. And the bank will look at the executor's ID, he would look at the will, but the bank would say, you know what, you check out, but the bank would be, we don't know if there's another will out there. We don't know if some other executor is trying to challenge you. So whenever someone's trying to challenges the validity of the will, so the bank in this case is essentially challenging the validity of the will.
My understanding was bank will never accept a will. You need to get a probate if they're asking. Institution.
Yeah. So the
stakeholders will always ask for it, at least in my experience.
That's absolutely true. Most financial institutions, be them banks, be them insurance agent companies, they all want the will to be probated because they want to make sure that this is the final will. There's no one out there who's challenging it. So the probate process is that.
But what is a probate though? They challenge the will has been challenged. Now what? What is a probate?
So the will has been challenged, and then the third party who's challenging it says we want some authority to certify that this is the final will, and the only authority which has this power are the courts. So the probate process is basically the executor makes an application to court to have the court certify the will and say that, yes, this is the final will, A. B, that the individual named here is the authorized executor. So there's no other executor. And the assets which are mentioned in this will are disclosed to the court. So the process is where the court basically certifies that this is the will. And then the executor can take this probated will with the authority entrenched in it to any third party, be it banks, be it insurance agencies, even mortgage agents or real estate lawyers would be like, we can't sell property until we know that you're authorized to transfer this.
Right.
So that's the whole reason why you have to kind of have the will probated.
But there's so many questions you need to from procedural perspective, I often see for tax purposes too, you just need to do it. You need to get inventory of all your assets.
Yeah.
List them what they are. Put fair market values, get valuations done.
Yes.
Then pay a fees. I call it a fees, but it really is a tax.
It's a probate fees. Yeah, it's kind of a tax. It's 1.5% of the value of your estate.
Yeah.
Is
I think probate, it's over Ontario is over 50,000, but 1.5% of the value of the estate, not the gain.
Yeah, no, that's a big chunk of change depending on how large your estate is. If you have a large estate, then that can be a decent amount of fees. Now, as to why is it 1.5, I think it's been 1.5 for the longest time.
Government loves 1.5 because that's the land transfer tax also.
They stuck it at that rate for some reason. There must be some historical pretext to it, but they just use that figure. It's 1.5% of the value.
But it really, two questions I have.
Yeah.
As a follow-up. One, do you really need to go to a court in front of a judge, or is this paperwork you're filing and they just give it back to you?
So basically, it's a paper application you would primarily do.
You're not appeering in front of a live court.
No. So basically, what my experience is in most probate applications, we take affidavits of their respective parties, and those affidavits are sufficient for court purposes. You don't have to present yourself. It's only when you have contested estates. Probate. So where you have two people making a claim to be executor or someone claiming there's another will somewhere, that's when the court may need further evidentiary presentation, and that's where you may have to be presented before a court. But most 90% of probate applications are non-contested in my experience.
It's just paperwork.
So it's just an application with the relevant affidavits that you need.
The second thing I had was, and I know the answer to this, but I think it's good to know, is that can you cherry pick an asset to be probated? Do you need to pay 1.5% on everything? So let's say, for example, I have an RBC bank account. It's got $500,000 in it.
Yeah.
But I have other assets, a couple $1 million in other places. And if RBC is the only one asking me for probated will,
Yeah.
can I just go and say, okay, I'll pay probate 1.5% on 500,000 and leave everything else out?
So no. So basically, that's a good question. That's where we do a little bit of planning for this situation.
But the default answer is what?
The default answer is you cannot cherry pick. So
Yeah.
basically,
Of course you can.
Of course you can. If you have a estate, if you have a will and you say all your property goes based on that will into the estate, then everything's in the same bucket. So you can't say let's probate this asset and not that. So the only way you can cherry pick is by doing something we call dual wills, two wills. One we would call it a probatable will. So those are all assets which require you to probate the will.
Or there's higher chances that someone in that basket of assets will ask you.
Will challenge the will, and therefore you need to probate it. And then you have a secondary will, which includes all those assets where you don't need to probate it.
I have a stupid question.
Yeah.
If I have 10 assets,
Yes.
can I have 10 wills? So then I have one will for each asset. So let's say in my RBC example, $500,000, I have a will for that. Then I have a house, I have a will for that. I have a private company shares, I have a will for that.
Intriguing
Intriguing
question. It is an intriguing question. I think technically there's nothing that I know that would prevent you from doing that. It's just that it would create considerable confusion in the sense of whether one has revoked the other.
Oh, okay. But it's so long as they talk to each other.
Or if, one will, there are two wills dealing with the one assets. So you gotta make sure it's airtight. But I've seen circumstances where you have multiple wills.
We do dual wills or multiple wills all the time because we know, given our clientele is like mostly business owners.
Yeah.
We usually say anything in the corporations and the shares of various companies you have, it's going to be separate into a separate will, and like all kinds of other related assets are going to be in that will. So we don't expect that to be probated. Okay. The corporation can survive. You can change their directors. You don't need a probate.
That's right. No.
But then everything else is really put into a will that we think will be probate. But I never had a question in my mind until now, talking to you, is that can I have not primary, secondary, but I can have like 10 wills for 10 assets?
Yeah, I guess if you're in the same jurisdiction, I've seen people have multiple wills, but usually, other than for probate reasons, the other reason why you have multiple wills is for jurisdictional purposes. So let's say, Sunny, I have a lot of clients who have assets in the U.S. and they have assets in Canada, and they may have some assets in the Middle East. So it's a question of whether you want to have a will for each jurisdiction. Which is
oftentimes people do have,
which is a common practice for foreign assets. They want to kind of have foreign wills because wills is a very how should I say it, sensitive about procedure and how the will is actually executed. So every country may have their own unique rules.
So if I have, let's say, a bank account in India, I have a land in UAE somewhere. Do I need Canadian will that will be enforceable in each of those countries?
You can definitely have a Canadian will, but the practical logistical issue would be that you have this will in Canada, it's been witnessed in Canada, it's been signed by you in Canada, and then your executor after you're gone would have to go to UAE, and then when they present it to the UAE authorities or Indian authorities, the Indian authorities may not accept it. They may say it's deficient in certain manners, that it didn't have certain procedures or whatnot, witnesses.
So you need a separate will?
So they may have you, it makes it more complicated. So you could have a separate will just for Indian assets.
So I'll have an Indian will for Indian assets, Middle East will for the Middle Eastern assets.
And then you'll Canadian will for the Canadian assets.
Do I need to, when I pay probate for Ontario, let's say Ontario resident passes away.
Yeah.
And how we went through the probate.
Yeah.
Does my Indian will need to be probated in Canada?
No.
No.
So basically, the concept is each will has its own estate. So it's a separate estate. So you would only pay probate on the estate assets in Ontario. You would not pay probate on your estate assets in India because that's a separate estate. So you can bifurcate. So for your foreign assets, the short answer is your foreign assets may not be subject to Ontario probate fees because you have it covered under a separate will.
Same thing, I guess, if you have very commonly people have like secondary houses in Florida, vacation property.
Yeah.
So if you have a U.S. property, you'll have a U.S. will.
You have
and
a
deal
US
with the
will.
estate taxes there and like all that other fun stuff.
Exactly.
Their own version. So you may have to pay their version of probate.
They may have separate
Like
rules.
Indian
Yeah.
wills might have probate there, a concept of that. Middle Eastern would have their own concept. You have to follow the local rules.
Local
if US
rules.
has it, you have to follow the US rules.
Because one of the most fascinating things, and you may come across this, especially for Muslim people in the Middle East, is that there's a concept called Sharia law.
What is that?
And Sharia law is basically Islamic law, which deals with the certain set rules on how inheritance is distributed. And you cannot change it. So they say that X percentage goes to your spouse, X goes to your kids, and so on and so forth.
Yeah.
You cannot deviate from that percentage.
Just like the Ontario intestacy rules that are codified in religion.
In religion,
Okay.
exactly. So you may have a will, but in the Middle East, that will may not be legitimate because it will contradict Sharia law. And as a result, your will be ineffective in the Middle East in that country which follows Sharia law.
So if I wrote a non-Sharia law compliant will and I go to an Islamic state,
which complies with Sharia law inheritance rules.
They will not honor
the
will that is written properly, but it is in conflict with the
the paramountcy of the Sharia laws would supersede the intentions you have in your will.
So how will they block me? Sorry, I'm just being like very specific. So like, let's say if I wrote it down and I'm like, okay, first of all, give me what are the ranking of who gets what?
So, I mean, it's a complex area of law, but generally on a short nutshell of it, it says that a deceased must provide for his dependents. And the definition of dependents in the Sharia law is your spouse, your kids, your parents.
Percentages?
So if they're alive at the time of your death, they're entitled to an inheritance. So
who is, like, how much? So let's say if I am a husband passes away.
So the percentages vary, but generally I could say general rule is that the spouse is entitled to 1/8.
1/8, that's it.
12.5%.
Okay.
Your parents are entitled to 1/6.
Oh wow.
So more. And then the remainder goes towards your kids. But depending on how many kids you have, the percentages kind of
doesn't matter
vary.
if it's a boy or a girl.
It does matter. So your wife, your daughter receives 1 share, and your son would receive 2 shares. So your sons would get double the share than your parents.
So if you go and like don't follow it, the government will not let you.
So basically, if you take a will and then you go to the bank and you say, well, I'm the executor, can you please distribute 50% of it or 100% of it to the spouse, the bank might object to it and say that's against the laws of Sharia, and therefore they'll prohibit you from distributing it that way. So in essence, they'll ignore your will.
Wow. So 3 action items if you had to give anybody who's listening to this, what would be?
So I would say the top 3 would be, number 1, you should definitely have a will if you want to kind of avoid confusion on who's in charge of your property once you're passed away. So that you appoint an executor.
So you have a will, yeah.
So number 1 is you should have a will. Number 2, I would say, is if we touched on this, if you have foreign assets, then you should definitely consider jurisdictional wills in each jurisdiction. And the third thing would be, and this is just practical advice, is just make sure that your executor knows where to find your will.
And your assets.
And what are your assets?
I'll give you the 4th one. talk to your tax accountant to figure out, am I paying too much in taxes?
That's absolutely
on
right.
death?
That's right. And then how do you minimize your taxes? Because there is a lot of ways that the government can take your money upon that.
All right. Thank you so much.
Thank you again.